This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about why a court refused to assist an insured in his attempt to defraud his insurer, and why a theft claim was insufficient to allow total gutting of the structure that was planned before the theft, and why it is always the obligation of an insured to prove his claim, not for the insurer to prove the opposite. In a case entitled Seviiri Bunjo versus State Farm Fire and Casualty Company, the Court of Appeals of Illinois, on May 19, 2025, dealt with an attempt to gain payment to remodel a building and found that it failed when the insurer refused to pay for non-covered claims. Bunjo sued for declaratory judgment against State Farm after a break-in at his property in Chicago on May 31, 2019. Bunjo sought additional insurance proceeds for incident-related losses and lost rental income. The Circuit Court granted summary judgment in favor of State Farm, finding that Bunjo failed to show the damages estimate was inaccurate or that State Farm violated the terms of the insurance policy. The court, in fact, found that Bunjo's contractor, Sean Rogers, provided an estimate for a full gut rehab of the property rather than just for damages from the break-in. Additionally, Bunjo's public adjuster, Vito Missio, admitted that he could not accurately assess the damages because the property had already been gutted. Regarding lost rental income, the court noted that Bunjo was under a court order prohibiting him from renting, using, leasing, or occupying the property at the time of the break-in. Perhaps that was why it was so easy to break in and steal from him. Therefore, State Farm was not obligated to pay for lost rents or additional living expenses because there were no rents he could have had. In summary, the appellate court affirmed the Circuit Court's decision to grant summary judgment in favor of State Farm, finding no merit in Bunjo's arguments. The Circuit Court properly entered summary judgment in favor of the insurer, where the insured failed to show the damages estimate was inaccurate or that the insurer violated the terms of the insurance policy, since State Farm only estimated the damages caused by the thieves. State Farm met its initial burden of production by establishing that plaintiff lacks sufficient evidence to prove his claim. This shifted the burden of proof to the plaintiff, and the court found that the plaintiff failed to bring forward any additional evidence regarding the extent of the initial incident-related losses, and therefore there was no genuine issue of material fact on the extent of the initial losses. Summary judgment, according to the courts and the law, should be granted only when, as here, the plaintiff's admissions on file, depositions, and any affidavits construed strictly against the moving party reveal no genuine issue of material fact, so that the movement is entitled to judgment as a matter of law. Because an insurance policy is a contract, the court applies general rules of contract interpretation to the policy, and if the words employed in the contract are clear and unambiguous, as is the case here, they must be given their plain, ordinary, and popular meaning. Plaintiff was planning to do a full gut rehab of the property before the break-in occurred. What's more, plaintiff failed to include appropriate citations to his arguments on the issues on appeal. As a result, the appellate court affirmed the Circuit Court's judgment, concluding that Bunjo did not present sufficient evidence to prove his claim. In my opinion, insurance, of course, is a contract that is designed to indemnify an insured for losses due to an insured against any fortuitous event. In this case, a burglary did some damage to the structure but did not destroy the structure or make it impossible to repair. Rather than seek repair only of the damage caused by the thieves, Bunjo sought to have State Farm pay for what he had planned before the loss, a full gutting of the property and reconstruction. The court felt it sufficient to dismiss the suit, but in my opinion, the trial court or the appellate court should have reported Bunjo to the Department of Justice for attempted insurance fraud. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 50 or 5,050 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.